Hi everyone, this is Mrs. McManus, and today's screencast is all about opening statements when we get to a trial. And so this particular screencast will only cover opening statements, and we will talk a little bit more about things like direct examination questions and cross-examination questions in a different time. So to begin with, the prosecutor or the DA starts the trial through an opening statement. And this is jury selection has already occurred, or if it's a bench trial, right, we've already had pretrial motions and all that stuff has already gone through. So an opening statement is the chance for both sides to give the jury or the judge an overview of what the case is about, what evidence might be introduced, what witnesses you might see, and so on and so on. So this should be brief because you want to be able to keep people's attention, but still long enough to make sure that there's all of the facts that you expect to prove. Now, it's very important not to be overly dramatic. Like, this isn't a movie. This isn't, Law and Order or one of those TV shows, because you don't want to overstep your bounds, because you could really tick off a judge or you could tick off the jury. And of course, you're trying to get the judge or jury to, side with your side of the case. And so you do not want to do that. Absolutely. And in addition, inflammatory or prejudicial statements are not permitted. It is not okay to say in an opening statement that the defendant murdered, the victim. No, that's prejudicial. That's already showing the jury that, this person is guilty, has been tried, verdict delivered, and so on. You can't do that. You need to make sure that you say, the suspect and that they were alleged to have killed, and so on and so on. That's very important, because if you say a prejudicial statement like that, the judge could actually call a mistrial, and bam, the case is over and you potentially have to have another trial. Now, after the ADA or the DA gives their opening statement, the defense attorney then does the same thing, and the same principles do apply. Some defense attorneys actually do choose to waive their opening statement because they want to first see what kind of evidence the prosecution is presenting. It's not super duper common, and I hate to break it to you, you will not be allowed to do that for our mock trial. For our mock trial, you will be required, if you're the defense attorney, to make sure that you do the opening statement. Now, here's sort of the theory behind the opening statement. This is your side's version of what happened. And so it should be logical, right? It should go in a logical order. It should fit the legal requirements of the claims that you're making, or perhaps the defenses that if you're the defense attorney, that you're potentially saying, my client acted in self-defense, or whatever defense you are launching with. It should be simple to understand. And it should be consistent with the jurors' common sense and their perception of how real life works. Remember that the jury is made up of average people from across your area or your state. And so therefore, you need to make sure to keep it simple and consistent with common sense, because you want them to be able to access it, right? And so a very good idea to have in your opening statement is some kind of theme. This could be a memorable word or phrase that kind of summarizes your theory. You want it to be emotionally compelling, incorporate the juror's sense of fairness and universal truths. You definitely want it to be simple as well. And then focus on people, not necessarily issues. People tend to resonate, like stories about people tend to resonate better with jurors. So with your theme, you should also translate this legalese, right? This law type language that can be difficult to understand into simple, compelling human propositions that are consistent with what the attitudes the jurors might already hold about people or events or life in general. Now, I should state that this theme should not be argumentative. Like, you are not making an argument in your opening statement. You are literally stating the facts. But you can still do it in an emotionally compelling way. And I'll show you some examples here. So let's say, for example, in a murder case, let's say the defense gets up in the opening statement and says, with her back up against the wall and her roommates threatening to kill her, Ms. Hughes had run out of options, right? So again, still stating the facts, but a little bit emotionally compelling. That run out of options is kind of that theme. Now, let's say the prosecution gets up and for their opening statement says, Pat Hughes took the law into her own hands. Now, again, the underlined part is a part that people tend to resonate with. They tend to understand what that means, right? So let's look at another one. This is another murder self-defense case. And this is, it says defense 2. Facing death, Sarah Baker did what all living things are instinctively programmed to do. She defended herself. Okay? So again, emotionally compelling enough, but doesn't go too far. And then the last example here is for negligence. Let's say it's a negligent homicide case, and the defense might get up and say, it is every driver's worst nightmare. A small child darts into the road. And again, the every driver's worst nightmare is what can really grab the attention of your jury or potentially your judge. Now, what to do in your opening statement? Tell a story. Focus on the people. Again, people want to hear about other people. So who are the important players? Personalize your party, whether it's the victim because you're the prosecutor or perhaps the defendant because you're the defense attorney. Make the story vivid and recreate the incident so that the jurors can see what happened. Make it emotional and dramatic to an extent. Again, you don't want to go too far because you don't want to tick off your jury or your judge. Keep it simple, keep it simple, keep it simple. I cannot stress that enough. Now, of course, be logical, concise. Walk the jurors or your judge through the events in chronological order is also very key. First, this happened, then this happened. This witness will show you that this happened, right? It has to go in a logical manner. And then see if you can anticipate the other side's weaknesses. That's okay to do in your opening statement. You can say something like, the defense is going to try to tell you that their client acted in self-defense. However, and anticipate what they're trying to say as the prosecutor and try to bring that up a little bit in your opening statement. Now, what not to do? Do not overstate the evidence. Do not include your personal opinions. They don't care about your personal opinions. They care about the case. And don't argue, at least not in a very obvious way. You're trying to state the facts, and of course you're going to put your own spin on it to make it emotional, but you can't be argumentative in an opening statement. Now, if we were to be in law school and they say, okay, here's how you should outline your opening statement, this is what they say. You should have an intro of some sort where you introduce yourself and your fellow attorneys. You should introduce the essential people, like who the defendant is or who the victim is. You should paint a picture of the scene for the jury. Discuss what the main issue is and what happened to try to get them to believe your side of the story. You should say why your side should win or not, And then number 7, anticipate and refute the other side. And then 8, conclude. Now, this could, of course, mean for a very large outline. And I did want to just sort of put this out there so that you can see, okay, here's what you would probably expect if you go to an actual trial and you see an opening statement. I shorten this for you, and here's what I'm asking you to do. I'm asking you still to have some kind of grabber or beginner, something that's going to draw the jury or the judge in. So this could be your summary of the theory. It could be your theme of the opening statement, however you form it. And then number 2, you should introduce who you are and who you represent. Or you could do that first and then do your grabber and beginner. Totally up to you. And then number 3, tell the story, paint the scene, introduce the players as they come up in this story, right? So for example, if the victim is the main person in this story, start off talking about the victim. If the defendant is the second person, make sure you mention them next, right? Introduce them in a logical manner. Number 4, have a short close, return to your theme, restate your theme. And then number 5, charge the jury or the judge at telling them what you're asking them to find. So you're going to say, Your Honor, in this case, so if it's a bench trial, Your Honor, in this case, we're asking that the judge find not guilty for the defendant, or vice versa. Okay, so that is a quick outline of opening statements. If you have any questions, please feel free to ask me during class.